So kind of talked about this. We have the grantor, that's the person setting up the trust, the trustee, the person managing it, and then the beneficiaries, who is going to basically see any benefit from this. In some trusts, the grantor can get income from the trust for their life, so they're a beneficiary. The grantor can retain the power, the benefit of living in any piece of property owned by the trust. So in a sense, they're a beneficiary there too. And then trusts, at some point, every trust document will read similar to a will that says, at the death of the grantor, here is what's going to happen with any trust principal and accumulated income. And that's where you can say it goes to my kids. Not only can you say who it goes to, you can say, if something happens to one of my kids, then I want his or her share to go to his or her children or my other children. For a Medicaid asset protection trust, one crucial part of this is once assets are retitled into the name of a trust, a house, brokerage account, stock, life insurance, bank account, the principal, mom or dad, they cannot unilaterally say, I want that money back, pay it to me. If they could do that, it would always be available for their nursing home care. So this is a big hurdle for a lot of people when thinking about whether or not they're ready to commit to use a trust like this to do asset protection planning from long-term care costs. They have to know that once this money goes in, it's not yours to pull out. So a conversation we always have, I had it with my own parents and clients every day. How much are you comfortable of everything you've accumulated and that you have at your fingertips of those assets? How much are you comfortable putting into the trust? And really the way I look at it is, what do you not plan to spend? So my parents had their house paid off and they had certain bank accounts that they had always held set aside for their children. They never planned to touch that. So instead of keeping those assets in that house in their name, subject to their long-term care costs, why don't we just set it aside outside their name? They're not doing anything different. They weren't going to use it either way. Let's set it aside outside their name in a trust so that once 5 years passes, they will know what we put in that trust is not subject to their potential long-term care costs. So people come into this planning thing, I'm going to impoverish myself, I'm going to be poor. And that's not the way it really should go. It should be thought of as, let's pick a comfortable amount of money that you think is going to let you enjoy your retirement, do everything you thought you'd ever want to do. And with whatever money or assets you don't think is going to be needed for that purpose, let's set that aside. And setting that aside into a trust, once 5 years has passed, it can be protected from long-term care costs. And by the terms of that trust, it will read very similarly to a will, but it will pass at death without the legal fees, without court involvement, without time delays that is related to going through surrogate's court in the probate process.